Elon Musk has just taken an extraordinary and risky step. He publicly linked Donald Trump to Jeffrey Epstein in a manner that places the current president within a relationship the Department of Justice never thoroughly examined. This is not a casual social media post. It is a billionaire with federal contracts releasing material that should have prompted government action long ago. From a prosecutorial viewpoint, this presents clear elements, statements from individuals, alignment of timelines, and indications of deliberate concealment, all underscored by the telling silence of the Justice Department. Let's be precise about the development. Musk disclosed specifics, images, travel records, overlapping timelines, tying Trump to Epstein during windows that were never included in any federal probe into Epstein's trafficking operation. This material predates the 2019 indictment, comes before Epstein's death, and existed prior to the Southern District of New York formally winding down its pursuit of co-conspirators. To a prosecutor, this raises a single, unavoidable question. Why was this never followed? The Epstein prosecution was led by seasoned SDNY attorneys, among the most capable in the nation. They possessed subpoena authority, cooperating witnesses, and access to financial documentation. Yet certain individuals' names never surfaced in the charging papers. Consider the sequence of events. Epstein dies in August 2019. The inquiry into his circle continues briefly. Ghislaine Maxwell is charged in July 2020. By that point, Trump occupies the presidency. He commands the executive branch. He selects the attorney general. The implications are obvious. What Musk is doing, intentionally or not, is constructing a public record that prosecutors cannot indefinitely disregard. When someone with first-hand access asserts concrete facts linking a sitting president to a federal sex trafficking conspiracy, that is not commentary. It is evidentiary material. And evidence does not lose relevance simply because an investigation fell silent. Here is how federal prosecutors would assess this. First comes credibility. Musk has access to information unavailable to most. He leads enterprises requiring high-level clearances. He is not an unnamed tipster. Second is corroboration. Flight manifests are records. Photographs constitute tangible proof. If they exist, they can be verified. Third is relevance. Continued association despite awareness of Epstein's conduct would speak to awareness and intent. This is not an assertion that Trump committed a crime. It is an acknowledgement that Musk has outlined a prosecutorial blueprint any capable U.S. attorney would immediately recognize. The obstacle is obvious. Trump holds the presidency again. He oversees the Justice Department. He has removed prosecutors known for independence and replaced them with loyalists. Therefore, the issue is not whether the information has weight, but whether anyone empowered to prosecute will engage with it. What remains largely unsaid is that the Epstein matter was never solely about Epstein himself. It concerned a broader network, a structure involving influential figures who enabled, joined in, or concealed a trafficking operation spanning decades. Time and again, federal authorities chose not to reveal the full scope of that system. In 2008, Epstein received an exceptionally lenient resolution from federal prosecutors in Florida, a non-prosecution agreement, sealed files, and minimal incarceration. That arrangement was brokered by Alexander Acosta, who later served as Trump's Secretary of Labor. To a prosecutor, coincidences do not exist. Move ahead to 2019. Epstein is arrested again, this time by SDNY. The case is strong. Then he dies, and momentum against alleged co-conspirators sharply declines. Maxwell is convicted in 2021, yet other alleged participants are never identified publicly. The client list remains sealed. Now, Musk releases this material, forcing the question of who decided to narrow the investigation's reach. Prosecutors understand that in conspiracies of this magnitude, cooperation is leveraged. Lesser participants are offered immunity to reach higher levels. But when those at the top exert control over the Justice Department, the entire process collapses. This is not speculative thinking. It is an institutional fact. To understand how independent federal prosecutors would proceed, consider the first step, confirming the flight records. The FAA maintains documentation. Private jet operators maintain passenger manifests, and if Musk possesses records placing Trump aboard Epstein's aircraft, those materials can be matched against official databases. The next move would be witness interviews. pilots, crew members, staff, anyone present during the relevant windows of time. Under federal law, specifically 18 U.S.C. Paragraph 1591, direct participation in abuse is not required. Knowingly benefiting from or taking part in an enterprise tied to trafficking is sufficient to create legal exposure. The following step would involve a deep review of financial documents. Did Trump and Epstein engage in business together? Were there transfers of money, investments, loans, or other financial ties that clarify the nature of their association? In conspiracy cases, prosecutors must establish agreement and involvement. They must demonstrate that individuals understood what was occurring and chose to proceed regardless. Musk's disclosures may supply the chronology and the surrounding context necessary to do that. Would this automatically result in charges? Not necessarily. Statutes of limitation are a serious constraint, as much of Epstein's conduct took place years ago. Many potential offenses may be time-barred. However, and this is crucial, there is no statute of limitations on concealing a crime. Lying to federal investigators, obstructing justice, or conspiring to hide evidence are independent crimes, and those can be pursued today. History offers clear examples. In the 1990s, prosecutors finally brought down organized crime figures who had seemed untouchable for decades, largely because witnesses eventually came forward. In the early 2000s, the Enron case demonstrated that even the most powerful executives could face consequences when evidence was strong and political will existed. In both instances, the decisive factor was not merely proof, but prosecutorial independence. At present, that independence is absent. This extends far beyond a single case. What Musk has done, intentionally or otherwise, is expose a core vulnerability in the system when the individual under scrutiny controls the machinery meant to hold them accountable. Consider the implications for the rule of law. If a sitting president can be credibly linked to a federal sex trafficking conspiracy and the Justice Department remains inert, what does that reveal about equal justice? If evidence is available but prosecutors are intimidated or compromised, what does that say about the integrity of our institutions? For anyone who has worked these cases, this is the worst-case scenario. Serious allegations, public testimony, a legal framework that demands action, and yet the accused oversees the very investigators who should respond. That is not democratic governance. It is autocracy dressed up with legal formalities. What happens next will be telling. Musk's claims will either be disregarded, which signals systemic failure, or fiercely attacked, which often indicates they strike close to the truth. Pay close attention to the White House response. If officials wave this away as nonsense, ask why they do not release records or welcome an independent review. If they target Musk personally, that is revealing. Prosecutors understand that when evidence cannot be disproven, the witness becomes the target. And if there is no response at all, that may be the most incriminating reaction, because silence in the face of precise factual allegations is frequently treated in court as implicit acknowledgement. The broader consequence is the normalization of a dangerous precedent, presidents becoming effectively immune from investigation. Not immune in rhetoric, we will still hear talk of norms and accountability, but immune in practice. Once such a standard takes hold, reversing it is extraordinarily difficult. The core reality is this: Elon Musk has placed a potential case in prosecutors' hands if they possess the resolve to act. The information is public, the statutes are clear. The sole remaining question is whether the justice system can function when power itself is implicated. I have spent years inside the Department of Justice. I have seen what happens when prosecutors are free to act, and what happens when they are not. What we are witnessing now is the latter. Watch closely who investigates and who averts their gaze, because the rule of law is not an abstraction. It is the dividing line between a republic and a monarchy. Stay alert. Accountability and truth depend on it.